I think the thing that is very significant about appropriation is what happens after, right? Like the second you are able to essentially don on somebody else's clothing almost as a mask for something that you want to do, what happens next? And I think that's the way I was looking at it, because at least for me, this idea of elderness, this idea of acting on behalf of the community in order to do something quite discursively violent, for want of a better phrase.
Everything in Kenya is always about ethnicity, as we sometimes joke to each other, but politics is most certainly about ethnicity, and this paper, this law, is about ethnicity. So I would probably invite you to put that up front, and for an audience that maybe isn't a Kenyanist audience, understanding that when people talk about community in Kenya, it is mostly a euphemism for ethnicity. To what extent are communities self-producing and, most importantly, demanding this law? Like, why was this law desired? What are the kind of power dynamics that feed into it? Is it coming from grassroots demand? Is it coming, as I suspect, from like a group of kind of intermediate actors, maybe sort of local elders who want to use this law to assert their position relative to politicians? And then how is that in the context of decentralization? So county level governments being empowered in 2010. Is this law a product in part from that empowering of that kind of middle tier of politicians?
People in power can use strategies, people below can only use tactics. It seems like the technology of traditional knowledge, or the technology of community can be used as a technology either strategically by the government to enforce certain things, or tactically by certain communities in order to maintain ownership of property rights.
The community is not the issue, but just the identification processes and the formalization, which in one way or the other seems to take us back to the colonial legacies that nationalism is trying to undo.
It's a wonderful initiative.
The GlobalSouth network opened new horizons for judicial cooperations.
GlobalSouth network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN, and the GlobalSouth network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Quiero expresar mi sincero agradecimiento al Dr. Naumen Riad.
Dr. Naumen Riad, the founder and convener of the GlobalSouth network. His visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally.
I would like to point out that Dr. Riad's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism.
We can rule when we want in the cases which are brought to us by citizens and residents. In the EU, this openness of mind is increased by the fact we apply, in some cases, same norms from the EU treaties or the EU directives or regulations.
After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings?
It's a great pleasure to welcome you all to the 46th seminar in phase 4 of the International Interdisciplinary PhD in Progress weekly seminar series organized by the GlobalSouth network. And before we begin, it's always good to start with introductions. I first want to pass sincere thanks to Dr. Norman Royat, who is a lecturer in law at the University of Leicester and the founder and chief convener of the GlobalSouth network, for his tireless efforts in organizing and leading this inspiring weekly series that continues to bring together scholars and practitioners from across several disciplines and regions. So my name is Dr. Joshua Ngulu, and I just completed my PhD in law from the University of Nottingham, the UK, and I'm currently a lecturer at Moi University School of Law in Kenya. And my doctoral research interrogated the place in law of the protection of cultural heritage, which is a very critical, it's critical to survival of indigenous peoples, especially in the coastal region of Kenya. So I was looking at it in the midst of infrastructure development taking place in a remote place called Lamu, which is along the Kenyan Indian Ocean. And I'm looking at, on one hand, development, which is key to opening up that remote area, but also how to protect cultural heritage. My concern was that the government of Kenya was not giving these people the right to be heard and participate in the development. And looking at an accountability framework of holding the state accountable through a principle called free, prior, and informed consent. So thank you, Norman, for the invitation. And it is a great pleasure for me to chair today's session for the GlobalSouth network for PhD in Progress. And I'm very much looking forward to hearing about the presenters' research, their ideas, and rich discussion which will follow. So I'm joined by two discussants who are with us, and we also have a peer commentator. Dr. Niels Boender is the first discussant for today's session, and is a scholar of African global history with a specialization in the political and intellectual history of East African decolonization at the University of Edinburgh. He is currently part of the project titled Global Socioeconomic Rights, Local Contexts, which is funded by Arts, Humanities, and Research Council. He, along with his leading team members, are collectively looking at the global history of social economic rights in relation to work in the period after the Second World War. And before coming to Edinburgh, Niels completed his doctorate at the University of Warwick on the legacies of the Mau Mau uprising in Kenya, especially as related to the politics of reconciliation. He's also working with the Iberia War Museum on the forthcoming Empire and Conflict exhibit. We're also joined by the second discussant, Dr. William Jones, who is a lecturer in ethnology at the Department of Arts and Cultural Sciences, Lund University. His research focuses on pastoral cultures in East Africa and the interaction with development initiatives. Specifically, he explores how well development agencies understand and integrate pastoral cultures in their development agendas. So his research advocates for making room for the voice of pastoral communities in the production and evaluation of development agendas that concern their well-being. Dr. Jonas recently completed his PhD in Ethnology, and as part of Lund University Agenda 2030 graduate school, his research focused on evaluating how well the Sustainable Development Goals are implemented at a local level. And we have our peer commentator, Ms. Christine Olando, who is an advocate of the High Court of Kenya and is currently a Commonwealth PhD scholar at Warwick Law School. Her ongoing PhD focuses on the right to higher education in Kenya, and her research interests in the areas of human rights law, intellectual property law and policy, education law and policy, and economic law. Finally, it is my great pleasure to introduce our guest speaker for today's seminar, Ms. Aileen Kimuhu, who is currently pursuing PhD in law at the University of Leicester, and her research focuses on the use of cultural and intellectual property to redefine the boundaries of citizenship in Kenya. She's also particularly interested in the interplay between culture, history, identity, and the legal domain. Some of her published works in Democracy for Africa, the Continent, or the Noruba Institute touch on the construction of identity, the dangers of colonial legacies and misremembrance, the obligations of diasporic Africans in the 21st century. So Aileen is presenting on a project which is titled The Production of Community as a Legal Subject Within Kenyan's Traditional Knowledge and Cultural Expression Act 2016. So Aileen will speak for 30 to 35 minutes, and then will be followed for 5 to 10 minutes comments from the discussants. And if time will allow, we'll open the floor for further 15 minutes for question and answers. And I will request the audience, if they have any question, they can put it on the chat box so that we can save on time. So Aileen, we are very delighted to have you, and the screen or the floor is yours. Welcome.
Thank you so much, Joshua, for that wonderful introduction, and hello, everyone. It's lovely to meet you. My name is Aileen W Kimuhu. I am a PhD student at the University of Exeter, and in my thesis, I ask what happens when questions of propriety, that is, questions of who gets to belong, who is proper, and who is visible, or rather, who gets to be visible, intersect with questions of property, that is, what is ownership, the nature of the rights associated with that ownership, and the like. And I'm looking at the intersection between these two concepts within the domain of traditional knowledge governance in post-colonial contexts, specifically Kenya. And I will not be presenting the entirety of my thesis. I will just be presenting one of my chapters, specifically my third chapter, in which I argue that in which I argue that Kenya's Protection of Traditional Knowledges Act, or the Sui Generis Act, appropriates the identities of communities of origin when producing and recognizing them as legal subjects. To make this argument, I will begin by introducing the Act and the definitions of traditional knowledge and community, finding that these definitions are rather ambiguous and introduce a circular relationship between traditional knowledge and community that is typically not captured within our conventional understanding of property, which is property as a relation between subject and object. Therefore, I expand what I mean by property in order to realize new questions to ask of the law, and I turn specifically to a legal geography and critical property scholar named Sarah Keenan, who argues, or rather whose theorization of property as a spatially contingent relation of belonging helps us understand that this reproduction of community as a legal subject isn't just about reinforcing a problematic colonial import, but about shifting the space in which such groups are embedded. This allows us to see how the ambiguous and prescriptive definition of community operates across multiple scales, and this elasticity permits the appropriation of identity, not by inclusion, but by the reduction of spaces of belonging. I know that was a lot, but we're going to get there. So we're just going to start off the very, very beginning, which is introducing Kenya's Act. So In 2016, Kenya passed the Protection of Traditional Knowledge Act amidst immense political concern about the misappropriation of knowledge resources from Kenya's ethnic communities. A majority of this concern was located around fears of national and local development, specifically how the misappropriation or misuse of these resources would impact their economic and social development. And it also followed from Kenya's new constitution, which in Article 11 heralded culture as the foundation of our civilization and obliged the state to protect it through intellectual property forms. And thus the Act was born. The 2016 Act recognizes and maintains the ownership of and control over traditional knowledge by communities of origin through sui generis rights, or rather sui generis intellectual property rights. These rights include economic rights, such as the recognition of ownership, the right to equitable sharing of benefits, licensing and assignment rights, and the right to be compensated equitably for the use of that traditional knowledge, as well as moral rights, such as the right to attribution and the right against derogatory treatment. Excuse me. However, this governance is contingent upon property law's own categories of identification and insistent upon categories like subject and object. And thus, we turn to how the Act defines both the subject community and the object traditional knowledge. The Act provides two definitions of traditional knowledge, one that is more for agricultural, genetic, and biological knowledge, and one that is more open-ended and generic. And it is the second definition that I'll be basing the rest of this presentation on. And that definition of traditional knowledge in the Act reads, and I quote, that traditional knowledge is any knowledge originating from an individual, local, or traditional community that is the result of intellectual activity and insight in a traditional context, including know-how, skills, innovation, practices, and learning embodied in the traditional lifestyle of the community. This appears to be a rather open-ended definition, especially that last sentence, which I bolded, embodied in the traditional lifestyle of the community, seems to take into account the fact that this knowledge resource and its value comes from the fact that it is embedded and cannot really be cleanly extricated or cleanly alienated from the life of the community. Likewise, community, and hence we turn our attention to community, likewise, community is elevated to a term of art, and it is defined as a homogeneous, consciously distinct group of people who share any of the following attributes: common ancestry, similar culture, unique mode of livelihood or language, geographical space, ecological space, or communities of interest. Like with traditional knowledge, this definition is seemingly open-ended. After all, a lot of groups share interests, ecological spaces, unique modes of livelihood or language, to the extent that us in this space right now might constitute a community for the purposes of this Act. And this is pretty adaptive, considering the fact that one of the problems intellectual property has is conceptualizing and accurately defining the legal subject when it comes to cultural properties and cultural heritage more broadly. However, the attributes that they have determined as constituting or perhaps reflecting community bear a lot of similarities with the ways that we think about identity, specifically identities that were formed in the colonial or post-colonial era. And by identity, to put it very briefly, I mean what makes us us, what makes them them, and how we interpret these answers to these questions. Briefly again, in these periods, identity was understood rather, not understood, but more an identity was understood as stable and knowable because it could be marked upon specific traits, and this stability was essential as a prerequisite for governance. And these traits were ancestry, geography, ecology, language, and so on. And it's not for nothing that these traits that we have in the post-colonial and colonial era that shape identity come back into the Act to shape what community looks like. Therefore, even though the Act appears to at first give communities of origin the freedom to position themselves, to self-identify based on their shared experiences, in practice, the legal process of recognition demands that the state, through its administrative machinery, select, delimit, and fix which markers count for recognition. That act of selection reproduces what we might call colonial legibility. And it is at this point where we have this, where we see the law producing traditional knowledge as something that is fixed and ownable, and doing the same thing likewise with communities of origin, that we start to see the similarities between these two categories of legal objects, and specifically how they might be co-produced. Because one thing that is very clear to me as I read through the Act again and again is that it appears that communities are defined by their possession of specific kinds of traditional knowledge, like culture, unique modes of livelihood, language, ecological spaces, bear a striking resemblance to the knowledge that would result from the activity and insight as a result of being embedded in that traditional lifestyle or in that community. And that slippage from sharing to possession is what enables community to be recognized as a legal subject. I argue that it transforms a relational practice that is sharing into a bounded form of property that is possession. And this occurs through almost a blurring between the lines of subject and object. Which means we might need to think a bit more broadly about how we think about property. And so it's important to understand that when I say property, when I'm thinking about property, I'm not approaching it as a bundle of rights as much as it is I'm approaching it as a legal concept. And although many legal theorists have pointed out that property might be socially constructed, most nonetheless approach property, at least theoretically, as giving the subject or a subject something fixed, permanent, and incapable of being legally interfered with by others. That is, property is a relation between a knowable, definable, and bounded object and subject who are predetermined before they enter a property relation. And this relation tends to revolve around the subject's right to exclude the world from that object. So, for example, my handy laptop that I'm using to present this presentation to you with is the object, and it belongs to me, which is the subject, and I have a right to exclude the rest of the world from my laptop. And this is typically summarized as a relation of mastery. However, these categories are rarely fixed, and neither subject nor object are predefined prior to their property relation. In fact, Brenna Bandar notes that the obfuscation of these very categories was necessary for colonialism to function. In the colonial state, we were both objects and subjects, objects for the purpose of economic governance, objects for the purpose of economic exploitation, there we go, and subjects for the point of governance. Thus, if the subject-object relation has never been a stable one and has been subverted by major economic institutions, and how ought to we think about property from a theoretical perspective? And this is where I came across the work of a critical socio-legal scholar by the name of Davina Cooper, who theorizes property through belonging. Belonging is a relationship of connection between part and whole, according to Cooper. And again, according to Cooper, conceptualizing property as belonging shifts the focus from the individual subject, that is me, and the thing to be owned, that is the laptop, and shifts it to the space and networks of relationships where the claim to ownership is made, supported, and legitimated. Property as belonging centers not only the legal entitlement, but also the spaces in which those entitlements can occur. And thus, property as a relation of belonging consists of two things. Consists of the subject-object relationship, which I briefly discussed and critiqued, and also the part-whole relationship. And this part-whole relationship draws from quite a different understanding of property, according to Cooper. Rather than items already in the category of potential property, that is, things that can already be bounded off from the self, this idea of property understands property as attributes, qualities, or characteristics of a thing. And for a moment here, I'd like us to pause while I kind of explain what that means through a very tangible example. And how Cooper develops this theory is through the use of a school. So that's also what I'm going to be using, because it is a very handy example. Now, many of us have, if you're lucky, probably have gone to school, and many of us have entered into a subject-object relationship with the school, which is in the sense that the school is the object and you as a student and your family were the subjects who held rights of access and license to campus and its facilities. These rights maintain a certain exclusivity associated with the campus and the kinds of students who can attend. However, as my therapist will tell you, schools are not just buildings. They are networks in which students, faculty, parents, staff, local communities are embedded. These networks have norms, expectations, and a model of what the ideal student means, which is to say that paying school fees is not enough, and in order to enjoy the full entitlements promised under a subject-object relation, students in particular must prove that they are a part of the school. That is to say, they must prove that they also possess the parts that make up the whole of the school. Speaking as a student, this meant performing a particular kind of respectability, wearing the right kind of uniform or the right kind of jewelry, speaking with the right kind of accent, and funnily enough, it's not this one, and knowing how to carry oneself in assemblies in order to signal to everyone that you are a part of this school. According to Cooper, as a result of these iterative networks shaping the space, the consistently high performance of the students means that the school is able to possess the trait of excellence. Affluent families means the school is exclusive. Good behavior means the school is safe. And according to Cooper, these traits become the properties of the whole. They define what the school is, constitute who its subjects get to be, or who its subjects are, give the school recognizable value, and provide the justification for the protection, preservation, and policing of that value. And as a result, therefore, property, this whole relation of property, is not simply a matter of owning something external, but of constituting parts within a whole and also constituting the whole itself. Therefore, relations, or rather thinking about property as a relation of belonging, helps us to understand, or rather, relations of belonging help to structure the identity and status of insiders and outsiders, and to thereby determine who can represent the past and present of particular locations. Belonging thus connotes a sense of propriety and of the proper, because as with the example of the school, ownership and membership are intertwined. Having is linked to being and property to identity. Now, what does this mean? Kind of like plugging this all back into the act for a moment. What does this all mean? First, it clarifies that circular relationship that I identified maybe 5 minutes ago. And it suggests that not only is there the subject-object property relation at work, but there's also a part-whole relationship at work. Second, it also suggests that the act and the way that it's been written, the way that it's been framed, suggests that the properties of community, that is their culture, their livelihood, their ecological spaces or geographical spaces, have now become the property of community. That is traditional knowledge and also expressions of folklore, but I'm not looking at that latter one. Thus, when the state recognizes a community as the owner and holder of traditional knowledge, it is not just assigning ownership, it is also producing community as a whole through the law. And because this producing community as a whole through the law, through the property relation, and because this property relation is necessarily situated and it is relational, we must have to ask, where did these relations take place? And this is where I began looking a little bit more into the field of law and geography, kind of using a geographical approach to deconstructing and understanding intellectual property laws generally, and sui generis intellectual property law specifically. Broadly speaking, because I'm aware that this is an interdisciplinary forum and we're all not lawyers, law and geography studies consider how law shapes physical conditions and legitimates spatiality. Legal geographers note that nearly every aspect of the law is located, takes place in, is in motion, or has some spatial frame of reference. And as a result, space and spatiality are the organizing principles of the legal geography scholarship that I've been reading. Space is typically seen as a process. Bearing in mind that this definition is going to be very brief, it's supposed to be instructive for the rest of this presentation, not necessarily definitive. And the definition of space that I'm relying on comes from Sarah Kenyan, who defines space as a process. And as a process, it is a product of interrelations, which means it is relational. It is always under construction, which makes it dynamic and mobile, and it also contains within it many different stories. So it is also heterogeneous. So according to Kenyan, space is a dynamic, heterogeneous simultaneity, which means space is necessarily quite messy. And Kenyan's reframing of space as the simultaneity of stories so far draws our attention to two things. First, and two things specific to Kenya and how we ought to understand the law and think about the law theoretically in Kenya. First, that the ways and the effects of white settler governance in Kenya's space in the past creates the social, political, and legal landscape of modern Kenya. Rather than emphasizing a liberal narrative of progress or focusing on the individual subject's experience of this history across time and space, Kenyan's definition of space allows us to imagine the accretion of social, political, and legal settlement forces on the spaces that we currently occupy. And number two, understanding space as active and not static enables an understanding of law's recognition of identities like communities, identities that the law has struggled to accurately capture, reflect, or define, which is to say that such recognitions are not just about bringing these groups into a dominant space, but about, as Keenan would later argue, shifting that space in which these individuals and groups are embedded, which means we have to now kind of turn to spatiality. And this refers to the roles that we play in the production and maintenance of space. It acknowledges that the space, for example, our homes, institutions, even this forum, are not natural and static, but are made through our interactions with each other and with the space and with the place and with laws. Seeing spatiality in this way allows us to transform our analysis from legal consequential spaces such as the state border to more creative explorations of the processes of bordering, where borders are understood not as inert, fixed sites, but as fluid, non-linear, and experiential practices produced through law. And now we turn more directly to consider Keenan's theories in full. Using this background in legal geography, Keenan uses spatial terms to theorize property, not as something essential or inseparable from the subject, but as a relationship that needs to be constantly reproduced by the space around it, end quote. Noting and building upon Cooper's work, noting that property is a relation of belonging, Keenan notes correctly that if it's a relation of belonging that takes into account the network in which that subject is embedded in, then we also need to take into account space, right? So Keenan then argues, well, property is not just a relation of belonging. Property is a relation of belonging that is spatially contingent, which means it has three elements: the subject-object relationship and the part-whole relationship that Keenan has identified, and also the extent to which this space holds up those relationships. The part-whole relationship, according to Keenan, refers not just to a constitutive relationship, but a positionality within a network of relations, the extent to which the subject is part of a group of persons that can lay legitimate claims to the object. And this positionality, or this process of being and being able to exist in this space, is what Keenan calls or refers to as holding up. And holding up involves routinized practices that structure the relationship between subject, object, and space, and it produces, according to Keenan, spaces of belonging. These spaces operate and form as a part of governance. That is, they can both keep property relations in their current place or act in a subversive way as an agent of change. That's something I'm looking at for the later chapters, not right now. But basically what this means is that to belong, and in order to prove that you have a valid and legitimate claim to property, community or members of the community need to show that not only do they have a legal claim, that is a subject-object relation, and that they are genuine members of the group, that is a part-whole relation, they also need to demonstrate that the law, policies, and practices of this space also supports this claim. And thus, our area of critical intervention when we're thinking about how to approach this theoretically should be, and I quote, how to recognize the movement and continual change in the fact that and in fact constitute the ongoing formation of the subject in its relation to its environment. I'm just going to read that again because the chat threw me off. I apologize. Thus, our area of critical intervention should be, and I quote, learning how to recognize the movement and continual change that in fact constitutes the ongoing formation of the subject and its relations to its environs. And now we go back all the way to the act, right? Back all the way to where we began. Recall that property is a spatially contingent relation of belonging, right? Based on Cooper and based on what Keenan has had to say. And also recall the fact that, as we've already discussed, the co-production of traditional knowledge and community. Now we have to turn our attention to that spatiality that upholds this relation. And I argue that that space of belonging that the act produces is tradition. And this is one area of my work where I have been struggling because, as I'm sure the people in my panel know, the meaning of traditional in colonial and post-colonial context is a thesis of its own. Now, this is one area of my work where I've been struggling. And because, as I said, like the meaning of traditional and post-colonial context is incredibly dense, intense, and heavily contentious. But we're going to get to that in the next slide. But for now, the reason why I mentioned some of my anxieties is because any feedback that you have for this section would be highly appreciated. So whilst I was doing my reading with Keenan and Cooper in mind, I realized that the Act produces tradition as a space of belonging. First, as a site, as we can see in section 19(1)(b) of the Act. Section 19(1)(b) of the Act states that traditional knowledge will only be protected when it is taken outside of its traditional context. This suggests that 1, there is a barrier between traditional and non-traditional contexts, that 2, these contexts are necessarily different, and that 3, it'll be clear when a knowledge resource leaves one domain and enters another. Let's be clear, the Act is producing tradition here as a legal technology. And whenever we ask, and the question of from where difference is allowed to emerge invokes the questions of space, spatiality, and within the community, within the economy of recognition. And indeed, the Act also seems to produce tradition as a space, because earlier on in section 2, the Act defines traditional contexts more as a space, noting its relational quality. They are characterized by its continuous usage, and the fact that this continuous usage is what enables generational transmission, is what enables that traditional knowledge to become embedded in the lifestyle of the community. However, there's also a certain amount of homogeneity that is a part of this, because if tradition is a part of communities and communities as a whole are homogenous, then there's a certain homogeneity, there's a certain flattening of that space that happens somewhere towards the end. So tradition as a space of belonging is relational and open-ended, yet clearly demarcated. And if it can be demarcated, it must be bounded and knowable. And as a space, the Act also seems to suggest that it pre-exists rather than it coming into production as a result of the Act. And this idea of tradition, that it is pre-existing, that it is demarcated and knowable, that it is bounded, that it is something that you can very easily draw upon as a prerequisite for governance, aligns very closely with the notion of invented tradition that we saw in the colonial era. Briefly speaking, I'm just going to skip by this because you don't have a lot of time, but feel free to read the slides. The colonial narrative in Africa is replete with instances and processes of naming things tradition that were not only used to reconstruct social realities and reproduce power and privilege, but also used to reinscribe and reify or denigrate African cultures. And then, as a result, what is termed traditional African culture, according to historians Terence Ranger and Eric Hobsbawm, could be a body of reified tradition invented by colonial administrators, missionaries, elders, and anthropologists, which is nevertheless in a bid to reassert our humanity and to celebrate our personality in the post-independence period. Different aspects of this idealized and invented tradition were drawn upon by post-colonial leaders in their attempts at nation building and to legitimize their own forms of governance in order to make them appear rooted in indigenous, authentic, and continuous cultural authority. This is not to discount the living traditions which are dynamic, but more to draw this discussion about invented traditions in post-colonial contexts into our discussion with how they ought to be governed in the law. Especially because invented traditions are characteristically invariant, employing fixed ritual routines and stereotypical symbols that result in the homogenic expressions that we've come to that the Act seems to privilege and expect from traditional knowledge. Remember, does it sound a bit familiar that the Act shapes or rather produces tradition as continuous, bound, distinct, and separate that results in homogeneous community? As a result, the question of tradition is not simply a cultural or spatial one. It also emerges as a technological one. So the state doesn't only inherit these colonial technologies of tradition, which is, it also actively relies upon them to produce subjectivities. And when the Act produces or constructs tradition as a space, that must be policed, certified, and managed, the state is allowed to step in as a role of traditional custodian in order to demarcate where this line ought to be. And through this legal process, the state appropriates the properties of community, reassembling and reasserting them in order to use it as a means by which to develop its own space of belonging. To appropriate property is to make something one's own by asserting or producing a relationship of belonging. In the Act, this appropriation did not occur through dispossession, but through definition. Communities and their ways of living, the very aspect of identity that made them subversive and so difficult to manage in intellectual property regimes, and the very aspects that have put their life worlds and world lives at risk, is made into a normative property defined by the Act using colonial standards. And this is seen through the circularity and of the relation between traditional knowledge and community, which again turns the properties of community into the property of community. Which this means that in effect, while the Act could recognize trade-based collectives, other linguistic or ecological communities, or other non-ethnic forms of belonging that might reveal the diverse ways traditional knowledge circulates, the space of belonging that it creates instead reaffirms the ethnic template as the proper form of community. Thus, although Section 2 defines community capaciously, the operative meaning of the word in legal and administrative practice collapses back onto ethnicity for better or for worse. Secondly, the community of origin also becomes a space in which the state can hold up certain relations of belonging, those congruent with this vision, and flatten and erase others which are not. This is because the definition is vague enough to encompass a number of communities, including the national community itself. The Kenyan nation can itself be seen to be a, again, for better or worse, homogenous, consciously distinct group of people who share ecological space, who share a distinct national language, who participate in a common cultural project or have a common interest. This interpretive elasticity allows community to operate on two scales simultaneously. The ethnic local, referring to, the Agikuyu, the Maasai. I know Joshua was speaking about the people of Lamu, so those people as well, and their communities as well as the nation state. With the former, the local communities creating and reproducing the spaces of belonging, and the latter being able to appropriate them for its own benefit. In other words, the Act collapses the spatial distinction between local and national belonging, enabling the state to position itself as both a custodian and beneficiary of traditional knowledge. Therefore, what is at stake here is more than the rights which are sought. It is also the social and cultural characteristics of these communities that use that traditional knowledge. Okay, we're nearing the end. So what are our key takeaways? Number one, that legal subjects are relational and intersubjective. Individuals and groups are recognized and produced in relation to the networks in which they are situated. And this explains the circularity between traditional knowledge and communities of origin. The Act, rather than laying the foundation for an open-ended relation between these bodies of knowledge and relations, fixes a comprehensible endpoint, that a community must already appear to be coherent, continuous, homogeneous, consciously distinct, and rooted in a stable tradition. In so doing, it closes off alternative trajectories of belonging, and belonging only becomes possible through occupying the space of tradition, and the space itself becomes a measure of who counts. And last but not least, in creating this discursive space in which we can appear likable as ourselves or as members of the community, these legal discourses, to me, attempt to embody or rather reflect the anxieties and desires that we dare not name, that the other side of community, which is the people who we do not consider to be our members, is dangerous or suspect and must be managed and policed by the community. And in fact, I go deeper into this when I do a phenomenological deconstruction of protection in intellectual property and a later chapter. Ultimately, all this is to say that all this is not to say that this is the. Ultimately, all this is to say that communities of origin need to have a lot more say in the abilities to define themselves in and through the law, but rather the way space and property and law operate together, especially in Kenya, appear to considerably narrow the conditions of legal possibility, at least when you look at them initially, and reinforces the state's power to determine who gets to belong. Thank you so much for listening. I do look forward to hearing everyone's comments.
Oh, brilliant. Thank you so much, Aileen, for the exciting presentation. That's brilliant. And so I will invite now the discussants to give their views, their critiques, their suggestions, and each will have 5 minutes. So I'll start with Niels, and then Aileen will note if there are any questions to respond to. You can note so that you can respond at the end of after Kristen. So we'll have Niels, we have William, and we'll have Kristen, and then you can respond together. Thank you. Welcome.
Brilliant. Well, first of all, Aileen, thank you so much. That was super interesting. I'm speaking as a historian of Kenya during the sort of late colonial period and decolonization. So I'll sort of read my comments from that perspective. First of all, I'd say I thought it was a really rich presentation that gave us non-lawyers quite a good perspective on where you're coming from and a very good analysis of the law itself. I really agree with your perspective of that sort of the intersubjectivity of the idea of community and the way in which like the law constitutes communities and the communities are kind of written into being through that. And we can see that, as you sort of pointed out quite wisely, we can see that all the way through the colonial period. But then a few sort of questions and prompts that I had. The first point is that it wasn't until I think it was slide 15 that we really talked about what the paper was really about, because the paper is about ethnicity. Everything in Kenya is always about ethnicity, as we sometimes joke to each other, but politics is most certainly about ethnicity, and this paper, this law, is about ethnicity. So I would probably invite you to put that up front, and for an audience that maybe isn't a Kenyanist audience, understanding that when people talk about community in Kenya, it is mostly a euphemism for ethnicity. And that results from the fact that its political system is broadly structured around kind of local sort of kingpins, as they're called, trying to mobilize votes, mobilize communities. So we should read the law in the context of that desire for people to sort of have the law reflect the kind of really existing situation. And that's something that I wonder how you reflect on, is to what extent are communities self-producing and, most importantly, demanding this law? And because that's kind of the thing that I think I was missing most, is you spoke about it for a couple of sentences, but you slightly glossed over it. It's like, why was this law desired? What are the kind of power dynamics that feed into it? Is it coming from grassroots demand? Is it coming, as I suspect, from like a group of kind of intermediate actors, maybe sort of local elders who want to use this law to assert their position relative to politicians? And then how is that in the context of decentralization? So county level governments being empowered in 2010. Is this law a product in part from that empowering of that kind of middle tier of politicians? Because, for example, in my own research, I've come across various counties trying to brand themselves as the Mau Mau County. And like, there's this attempt to sort of increase the heritage that is available to sell themselves as the Mau Mau County. And that story is often read through the lens of decentralization. So I wonder about that. I would also suggest that you read Terence Range's second article, because 10 years after the original Imagining Traditions article, he wrote a second article reflecting back on it. And in that, he made some of the points that I'm making now, which is the sense in which communities are also something that people themselves use as a tool to protect themselves from power. John Lonsdale's work on moral ethnicity, I think, is super useful as well, in the sense that ethnicity is also an arena in which people themselves debate about kind of what is the correct form of moral government, and that ethnicity, rather than being this exclusionary category only, as you kind of presented it, it's also a category that in which kind of leaders can be held to account. And I wonder how that perspective of thinking about the kind of productiveness of ethnicity and the productiveness of local communities, and the fact that it is a way in which many everyday people at the grassroots feel included in a political system, might draw on and actually find this law a way that gives them a bit of identity, a bit of recognition. That's just something like, I can see your arguments against that, and they're good arguments, but I think it would be worth getting into the mind of the legal scholars who came up with this law and the political power dynamics that are at its root. Also, you didn't talk about land at all, which makes sense because you're talking about cultural tradition. But if everything in Kenya is about ethnicity, everything in Kenya is also about land. And I would might be quite interesting to think about how communities talk about land and try and turn land into property, and how that might relate to how people think about cultural property. There's also a really rich history about that kind of links to the stuff you were saying about settler colonialism as well, because, and this will be my final point because I realize I've come to the end of my 5 minutes. It was settler colonialism who treated Africans as a mass of kind of amorphous others who could be dragged into labor without sort of acquiring rights of property or rights of sort of identity. And people in the late colonial period, and this is in the work of Lonsdale and Ranger as well, people turn to communities as a way of preserving themselves from the kind of grinding enemy of individualist settler colonialism. And that sense of ethnicity as being something that people turn to protect themselves from settler colonialism, that might be an interesting provocation for you to think about as well. But yeah, as I say, really, really enjoyed the presentation, and I hope some of those comments were useful.
Thank you, Niels, for those comments. So we go to William.
Yeah, I mean, I'd like to echo what Niels says there. Just a really interesting, fascinating presentation, really well presented, really enriching, really enlightening for me. I learned a lot of new things about the legal system, also about legal scholarship. I have a couple of questions about your main argument, which, as Niels said, kind of came to after slide 15. As I understand it, your main interest, your analytical interest, is in the appropriation. We had a lot about the theorists and a lot of the background about what the law is and how it's constructed and so on, and very clear details of that. And it wasn't until we got to the appropriation, which is the meat of the matter, which is why which is kind of what I was looking for. I want to hear much more about this element of it, and I want to know about what's the intention? What's the aim of this? Why are we looking at appropriation here? Why is it important to you? What's significant about appropriation, and how can that help you drive your analysis further? I think it's worth going back to this. Go back to this question of what do I want to know? What is it I actually care about here? Why do we care about this? Why do you care about the community and the concept of community and traditional knowledge, and how does it relate to appropriation? You touched on a few things here, because I think these are going to be the things that really make your argument stand out and make it really shine. Some of the things you talked about in appropriation terms about questions of appropriation by whom and to what end. These are effectively the things that it seems like you're looking into. Political appropriation kind of seems to be the main one. Touching on what Niels is saying as well. Appropriation by certain ethnic communities or leaders of ethnic communities in order to maintain political power. Is this what you're looking into? And if so, how does that perspective help us unpack the limits of the legal concept itself? Or is it about land grabbing? Is this going to be something else that's more interesting for you? Or is it about appropriation of certain so-called traditional technologies in order to abuse or maintain certain hierarchies of privileges of power, such as gender hierarchies? If we look through these sort of lenses and start to think about who is appropriating these laws, who's using these technologies and for what ends, how can that tell us about the limitations in it and the boundaries of the legal concepts themselves? And linked to that, I think it would be useful, it might help to think about, you identified two scales of which the technologies are being used, and by two different types of actor. Some by the legal systems themselves, the state themselves, and other by players who are trying to push back against it. So one way to look at this may be to think about it in terms of strategies and tactics. Michel de Certeau talks about people in power can use strategies, people below can only use tactics. It seems like the technology of traditional knowledge, or the technology of community, can be used as a technology either strategically by the government to enforce certain things, or tactically by certain communities in order to maintain ownership of property rights. An example there of the tactical way of thinking about is in Il Chamos group in Bagoria, how they used the idea of community to in order to secure land rights. Okay, 13 seconds. So just one final thing I think to dig into then is the theoretical elements you talked about. You talked a lot about the part and the whole, and you kind of touched on temporality. I think it might be worth you looking a bit more into temporality of this, how over time technologies change. And then very finally, very quickly, I think that it might be useful for you to look into traditional structures of governance or types of authority which have traditionally been used by certain community groups, and such as gerontocracy or the Council of Elders and so on, how can these tools be used? How can you use them to understand how the technology of what is considered a static technology of identity or community knowledge, how is it actually in practice seen and utilized as like this changing, ever-changing dynamic processual concept? And maybe that will give you insight into different perspectives on the legal phenomenon itself. And I'll stop there. Thank you very much.
Thank you so much. Thank you so much. Kristen?
Thank you so much. Thank you, Aileen. Such a rich presentation. And it's just fascinating how you're able to link property with traditional knowledge and culture. So to begin with, I also recognize the importance of just acknowledging how the Kenyan nation is structured. It's a very pluralistic, I speak as a Kenyan for the audience. I'm Kenyan. I grew up, was raised in Kenya. So the Kenyan society from knowledge and from experience is a very pluralistic society. We have 47 tribes, and just because of all the tribes, and each of these tribes has its own languages. I myself am a Luya. In the Luya community, there is 18 sub-tribes. And so that's the type of society and nation that Kenya is. So having said that, also, I would have liked to hear more about, recognizing that the international framework of intellectual property has not fully embedded the place of traditional knowledge as an IP in and of its own. And I know WIPO has been negotiating an instrument for about 20 years, but generally traditional knowledge and cultural expressions is very fragmented, and it's still evolving in as far as the international framework is concerned. And that's why it was increasingly necessary for African countries, Kenya included, to come up with their own framework of protecting traditional knowledge and cultural expressions. So that background would help to really sort of make the audience understand how this fits into the international regime. And then the discussion really reminds me about the discussion about alternative dispute resolutions, alternative justice systems, and whether that should be formalized or not. And I see a lot of similarity between that discussion and the discussion of TK, because I kept on wondering, is the issue the definition of the community, or is the issue the legal process of appropriating the what a community means? Yeah, because if it is the latter, then it means the community is not the issue, but just the identification processes and the formalization, which in one way or the other seems to take us back to the colonial legacies that nationalism is trying to undo. And so I'd like, if possible, if you can reflect a little bit more on that. And then the issue of, so I understand when you talk of the need for autonomy and the space for self-identification, but the reality is that a lot of the Kenyan community takes on identity partly based on their communities. So for instance, I was born in a family where my father is a Luya, my mother is a Luya, and I've just taken on that identity. I'm a Luya. I've never questioned, I've never disputed. Yeah, and a lot of Kenyans can resonate to that form of identification. So I'd like if you could reflect more on the feasibility of undoing this mode of appropriation. And Luyas are known to come from Western Kenya, like Luos are known to come from Kisumu, Nyanza, Coastarians are known to come from Mombasa, and all that, which fits into the categories that the Act lists when explaining what a community is. Finally, as I conclude, part of the reason the Act was enacted is it's positioned as a means of gaining royalties and making the community benefit. So without the Act, then how would the communities benefit from their traditional knowledge? That's it.
Thank you so much, Christine. Thank you, William. Thank you, Niels. So I'll invite Aileen to respond to some of the issues raised, the questions. Evelyn, you can take a few minutes so that we can see whether we have anything from the audience if time allows us. Welcome, Aileen.
Okay, thank you so much, everyone, for your very helpful comments. A lot of these things are things I'm going to have to reflect on in the course of the coming months as I'm continue writing up my chapter and continue working on the rest of my thesis. So whatever I have to say right now will be more of a gut check reaction than anything particularly reflective. But to start with Niels, thank you so much for the reading recommendations. And you're absolutely right about me having to foreground ethnicity as one of the things that I have to explain to my audience. It is something that I've had to struggle with because, yeah, the institutional struggles are irrelevant. But to answer your question about the extent to which communities might be demanding this law, this is something I've been really struggling to answer because when I try to look for specific case studies where I can tell that a community of origin has specifically used this law to foreground or to shape their interaction with potential users of their traditional knowledge, cultural expressions, or more broadly, cultural properties, I haven't been able to find any, and I'm not sure if it's because they don't exist, and I doubt that. And I want to think it's because of an access issue for me. Like if something is happening, it's definitely on the ground and it hasn't made its way back up to external audiences. For example, the example that was used to push through the act and kind of justify its necessity, one of the examples was when Louis Vuitton appropriated the Masai Shuka. I think it was Louis Vuitton appropriated the Masai Shuka and turned that into a high fashion design without acknowledging or recompensating the Masai community. And they went with like a private contractual, almost like I think you called it free and informed consent framework, instead of going through this act, which I found very interesting, but another research topic for another day. As for Williams, thank you so much about your questions about appropriation. Those are the ones I will need to reflect on. I think the thing that is very significant about appropriation is what happens after, right? Like the second you are able to essentially don on somebody else's clothing almost as a mask for something that you want to do, what happens next? And I think that's the way I was looking at it, because the case study in which I am using to unpack this question of the relationship between propriety and property in post-colonial context as it concerns the governance of cultural expressions and traditional knowledge is the example of there was a pride flag that was planted atop Mount Kenya 2 years ago, and the community, my community, some of the elders, well, people calling themselves elders, climbed the mountain, took the flag down and burnt it. And they seem to have appropriated, at least for me, this idea of elderness, this idea of acting on behalf of the community in order to do something quite discursively violent, for want of a better phrase. And for me, that's why the theme of appropriation is so interesting to me. And for Christine, The bits about the international framework, that kind of context level stuff, is the stuff I'm writing for the earlier chapter. And then I move on to the more theoretical stuff later on. Thank you so much for also clarifying about like what is the problem. That was a great question. Thank you. And also for asking me about the feasibility about undoing this mode of governance. To be honest, part of the reason why I have a love-hate relationship with this act is that it has so many wonderful things in it that I don't necessarily want to be undone. However, just Kenya being what it is, I think the argument, that the conclusion that I'm now drawing to is that Kenya being what it is means that we, as the people who are coming to this law, engaging with this law, have to think about it differently, because we can't rely upon the state or the government or the institutions that implement the law to be that innovative or to be that creative. But in order for us to know how to think about it creatively, we first have to understand where the pitfalls lie. And I think that's where I've situated my project. Hopefully I was able to respond to all your questions. If not, I have your emails, I'll grab your emails, and if we can do a bilateral. Thank you so much, everyone.
Thank you, Aileen. That is wonderful. That's great. That's brilliant. We supposed to be coming to an end. I'm not sure whether we have some comments in the chat. Just to thank you for your very insightful comments. So we may not open up to the audience. My question, so that I think it's a critical question for anyone pursuing their PhD. Your research methodology. It becomes a very critical question when you are writing and you are researching from the start to the end. So you may not respond to this, but just looking at the comments, the multidisciplinary approach in your research, just asking myself, apart from the doctrinal, research, what other methodology are you applying in your research? You may not, respond to it, but you can say one sentence, and then we can, conclude the session. Thank you.
I am doing a doctrinal and a theoretical approach to my research. Specifically for the theories that I'm looking at, it is post-colonial scholarship, Africana scholarship, and queer scholarship. We don't really have the time to get into the reasons why, but the overarching, again, if I'm looking at questions of who gets to belong, who gets to be visible, the terms under which those positions are determined, I found myself gearing more towards critical studies, post-colonial studies, and by queer also mean queer, and Africanist studies. Africanist especially because I needed a way to think and talk about the law in a way that felt familiar for our contexts, because that's, at the end of the day, that's who I'm writing for, and that's what I'm writing about.
Thank you so much. So ladies and gentlemen, we come to the end. I want to make a few comments just to, thank you very much, Aileen, for the insightful and very, very brilliant, stimulating presentation on your PhD. And your work, beyond doubt, makes a very valuable contribution to the broader discussions on cultural expression and legal identity in an unstable socio-legal context. It has given us much to reflect on. So I want to thank our excellent discussants, Dr. William, Dr. Niels, and our peer commentator, Christine, for their very thoughtful and engaging feedback, and to everyone who has joined us today for participation and the support you have accorded Aileen. So the network, the GlobalSouth network, warmly welcomes PhD students from all disciplines and from every corner of the world to share their research and receive interdisciplinary feedback. And if you are interested, of course, you can pass this on to our networks in presenting your work or taking part in a future research or session. Please, you can contact our founder, our convener, Dr. Newmat, at the email address which is shared in the chat box. Norman, I think you have shared your email. You can check that and then you can share with our networks. So next week, again, we have a presentation from Das Shibani, who is a PhD candidate at the School of History, University of Exeter. and he'll be presenting their PhD project titled "What's Indian About the Indian Telegraph Department: Exploring the Human Side of Communication Technology in Colonial India, 1920-1947." This is on the 26th of November 2025, or between 3 and 4 p.m. UK time. So thank you very much. And until then, we invite for you to attend, and of course, any future presentations. So please take care of yourselves, look after yourselves, and have a very wonderful day. So goodbye, everyone, and see you soon. Bye-bye.
Thank you. Thank you, Joshua.
Thank you.